In this week's It's the Law, we're talking to Attorney Jay Davis about the case surrounding the Bibb County Middle School teacher charged with sexual assault. Plus, we'll answer your questions. Good evening, Jay. Thanks for being here tonight. Now, what type of evidence do you think it was that led police to actually charge the teacher with sexual assault?
Well, it appears in this case that probably the only evidence they had was the student. Apparently, a 14-year-old student has accused the teacher. And usually in an assault case like this, a lot of times it's just an alleged inappropriate touching. So that's going to be one person says, another person says. That's probably what we're looking at here. And then the evidence as a whole will be looked at as whether or not it's believable.
Okay, now just in general, in your opinion, in a sexual assault case, does it matter if it's a minor? Would maybe police charge somebody more because...
Well, in this case, the sexual assault is actually because he's in a position of authority as a teacher. That's probably why he was charged. This is a 14-year-old. He could have been charged with child molestation, which in this case could have led to a lower or lighter sentence. But because of his position as authority, a teacher, a music teacher in the school, he's going to be charged with something that would carry a weightier sentence.
All right.
And because the boy's young, it probably could lead to a 25 to 30-year sentence.
Okay. Now, today in court, the teacher actually waived his right to a hearing. Why would he do that?
Well, that's actually normal. When you always have the right to remain silent, most of the time that's the best right you can invoke, just to not speak. The evidence that's going to be looked at the bond is what evidence they have against you. And no matter how well you controvert that evidence, you're probably going to get a bond based on those charges. And we usually do not, at a bond hearing, go into the evidence or have someone testify, unless on occasion you have where you don't believe the person's telling the truth, you believe the judge needs to hear why the person may be lying, and then you want to give some evidence as to those.
So that really wasn't out of the ordinary.
That was not out of the ordinary.
All right, let's get to a viewer question. Switch gears here. This one's from Peggy. She says, if you are in jail for violating probation and are given a public defender, can they refuse to see you, or are they supposed to meet with you when you ask to see them? How are they supposed to know anything about your case if they refuse to meet with you until the day before your hearing? Okay, that's pretty much 3 questions in one there. So how can we help Peggy
Well, the
out?
bottom line is sometimes you get what you pay for.
Okay.
That's why we do well as defense attorneys. There's people who want somebody they feel like they get aggressive representation. However, any attorney, you're not necessarily going to walk in anytime you want, even if you've got a paid attorney. You don't get to call them up and say, hey, I want to talk to you right now, and they drop everything to see you. A lot of times public defenders, there's very good ones and there's some not so good ones, the same as there are with paid attorneys. But a lot of times they don't see a client until right before a court hearing. If that's an arraignment and you're generally going to plead not guilty and then look at evidence that the DA may later give you, then that may not be a bad thing. But normally you want somebody to get you aggressive representation up, right off the bat and start defending your case.
All right, sounds like you're saying, Peggy, if you can afford it, you might want to get an
You might want to come
there.
over here and let's talk.
All right, Jay, thank you so much. We appreciate you being here. Now, if you would like to get your legal questions answered, send us an email to itsthelaw@41nbc.com.